There's a foment of mortgage excitement in the room, and it's going to continue for another half an hour or so. We've been talking about the conduct of the sale of itself. David, I'm wondering, back from the mortgageor's point of view, can a mortgagor offer to match a proposed sale price? Indeed, can the mortgagee sell to the mortgagor themselves?
There's basically two questions there. As to the first one, there's no reason why a mortgagor can't make such an offer, but to flip the coin over, there's no concept of the mortgagor having a right of first refusal or something like that. So there's no obligation on the part of the mortgagee to make any offer to the mortgagor, but by the same token, there's no reason why the mortgagor can't step in, join in the fund. And indeed, the mortgagor can be the buyer. There's nothing to stop the mortgagee buying, but there is one important point to watch out for. One of the effects of registration of a T3 transfer from a mortgagee is to get rid of all subsequent mortgages now, and that's set out in the statute, but the statute makes it clear also, I'm talking about section 77 of the TLA, in the case of the mortgagor itself buying, subsequent mortgages remain on title, so it's not, the mortgagor shouldn't think that it can dispose of prior encumbrances by buying the property back.
Robert, you referred to the Lagudi case earlier. Does that shed light on this idea of whether a mortgagee has to give the mortgagor an opportunity to be involved in the sale?
Well, a mortgagor doesn't have to give the mortgagee an opportunity. I'm sorry, yes. Mortgagee doesn't have to give the mortgagor an opportunity at all, no.
What about reserve prices? Who gets to set those, and how should that be done?
Well, the mortgagee obviously sets the reserve, but that should be done on a sworn valuation. I would think a mortgagee would be very careless in not doing that. If a mortgagee can reject the highest bid at an auction if it's below the reserve fixed by a competent valuation. So the valuation is quite important, as you can see. If the reserve price has not been reached, the mortgagee doesn't have a duty to negotiate with the highest bidder. Of course, it can. When I say these things, there's no absolute black and white in any situation here, but this is what you'd expect from a normal, competent mortgagee. So it sets the price, it controls the auction, and is not bound to accept offers, the highest offer, if it's below the valuation. The reserve, sorry.
And of course, although there is no black and white rule, it's important to consider these factors because as is usually the case, the principle of not sacrificing the mortgagor's interests, of behaving in a reasonable way is fine in theory, but these are the steps that are going to be combed through by a mortgagor who's looking, of course, to stop a sale under any circumstances, or a mortgagee defending their right to be able to realise the security without giving the full optimal sale treatment on the mortgagor's behalf. So if there's a definite offer by an intending purchaser by private contract, say, and then some third party says, well, I'll bid higher if you take this to auction, can the mortgagee proceed?
With a private sale, you mean?
Yeah.
Yeah, well, the mortgagee can proceed with the private sale, but again, it's the mortgagee in those circumstances really needs to try and do some investigation of the third party. But if they can get a firm contract straight away with a proper price, that is often preferable than taking the gamble about whether that person will really bid at the auction. I mean, you can't guarantee that. And the mortgagee doesn't have to take too many risks. It's entitled to get its money in, provided it obtains a proper price. So it's really going to be a matter of judgment. If obviously the third party potential bidder is a respected organisation that's well known and it's indicated, yes, I'm going to bid this kind of price, well then a mortgagee probably would want the the auction to go ahead, but it's not bound to.
And in most cases, wouldn't a mortgagee rather have a bird in the hand and a sure sale rather than a risk of a higher one?
Indeed, in all the cases about whether mortgagee has exercised its duties properly, the courts do take into account the problem that a mortgagee faces with ongoing interest, delays, having to spend money to preserve the property. I mean, I often hear mortgagors complain about this, and you point out to them the mortgagee is actually expending money, and it's the default interest is increasing while the mortgage is not being paid. So courts do take that all into account in deciding whether the mortgagee is acting appropriately in going ahead with a sale.
In many of the larger loan arrangements, obviously there's more than one property that's taken as security. Can a mortgagee decide the order in which properties are sold or choose which property to realise?
Well, Section 77 itself doesn't allow a mortgagee to choose the order. I mean, probably the most famous case we've had dealing with this in Victoria is the MBF and Nolan case, and in that case there were 3 lots of land. The mortgagee sold the first lot, which was vacant land, and then sold a house lot, and that still didn't realise the debt, and then sold the third lot, the second vacant lot of land, and the mortgagor complained that if the second vacant lot of land had been sold before the house lot wouldn't have had to be sold. And at first instance, Justice Vickery held that the mortgagee had breached its duties because the mortgagor had a special sort of home interest. It's a concept I hadn't heard of before. But the
no one had.
Yeah. I think it was espoused first in the castle.
Well,
I don't have the authorised citation for that.
I'm going to be a bit more polite than that. In the Court of Appeal, there's a very good explanation of a mortgagee's duties in this sort of situation. If it's not necessary for a mortgagee to sell all the pieces of land, it is appropriate for the mortgagee to listen to the mortgagor about which piece of land it wants kept. And the Court of Appeal indicated in its judgment that if there was no reason to sell a particular piece of land that the mortgagor was wedded to, the mortgagee may well be in breach of its duties. However, if the situation is it's not clear whether the debt's going to be cleared by sales of any particular pieces of land, the mortgagee can still sell in whatever order it chooses to look after itself. But if, as I said, if it's clear you could clear the debt without selling the piece of land that the mortgagor is particularly interested in, the mortgagee should take account of that in choosing what it sells.
I can imagine a situation where, for example, there might be a particular piece of property on which there's a going concern that's actually an income-producing asset, and then subsequent ones. I can imagine a mortgagor being quite concerned that their golden goose might be sold out.
That's a classic situation. So if you had an income-producing asset and the debt could be cleared without selling that asset, that the mortgagee should sell the non-income-producing assets. This whole issue about selling multiple lots always causes problems, though. Many of you would be familiar with the expression selling in line. There's been quite a few cases, say, where a development falls over and the mortgagor sells 15 apartments in one hit as opposed to selling them individually, separately. There's always problems in that area. There's been a couple of major cases in Victoria about that. The position appears to be that it can be done. Obviously, you have to look at the mortgage first. The 2 questions: is there the power to do it? And secondly, is it appropriate in the circumstances? Once there is the power to do it, the court then looks at is it appropriate in the circumstances, and a mortgagor won't be successful in challenging this by saying, oh, you could have got a better price by selling each one individually. If it was reasonable for the mortgagee to sell like that, selling all the lots together, that will be okay, provided it, again, goes through the proper marketing process and what have you. The court doesn't say, oh, there's 2 market valuations, one for private individual sales and one for an inline sale. The court says once you determine which is the appropriate process to go through, you only look at that market valuation for that process. So there's 2 questions. Is there the power to do it? is the process okay? And it's quite okay in many instances for a mortgagee to sell the properties in line because of, there's a problem I mentioned earlier, ongoing interest, delays, expenses in maintaining the properties, having to repair the properties, keep them in good nick. Other problems can arise though if there have been cases where mortgagees have sold under pieces of property that are under separate mortgages and sold them together. More problems can arise in those sort of situations, as you can imagine. And of course, if you do get to a court case, there's the problem of apportionment, because the court will then, of its own volition, work out how much money should be attributed to each property. So you have to be, mortgagors got to be very careful in how it goes about doing these sort of things.
An added difficulty occurs, David, you've foreshadowed this, after a contract of sale has been entered into and the rights of third-party purchasers intervene. David, can the mortgagor lodge a caveat over the property in an attempt to prevent that situation from arising if they feel they want to contest the liability?
Well, a better bet I'd suggest for the mortgagor in that situation is to simply injunct, as the Americans say, or enjoin, more correctly, the mortgagee from completing the sale. A caveat which is, sorry, I'll take a step back. Some supposed entitlement or potential entitlement on the part of the mortgagor to have the contract of sale set aside by the court is not an interest that will support a caveat. So that's been so held in a 1994 Victorian case, Swanson Mortgage and Trepan Investments.
At best, it's a shows in action that the mortgagor might have rather than an equitable interest in the land.
Yes, well, it's an equity if rather than an equitable interest. So the other possibility is, of course, that a mortgagor could lodge a registered proprietor caveat, just claiming an interest as registered proprietor. That might be open, but I suggest that that's liable to attack as having been lodged really for an ulterior motive to serve no purpose other than to try and block settlement of the sale. The mortgagor may have some difficulty maintaining that caveat. Better off just to go to the court and get injunctive relief.
Could I just add something to that? David mentioned the fact that a mortgagor can't lodge a caveat. In a recent case called Vassaloo and Westpac Banking Corporations, 2007, there's an invitation there for any of you that have very wealthy clients to challenge the correctness of the Swanston mortgage. This is what I think it was Justice Buchanan said. It may be the correctness of the Swanston mortgage decision requires reconsideration, but unless and until that decision is overruled after a full hearing before a bench of 5 appellate judges, we're bound by it. So there is an invitation there for anyone that wants to go up to the Court of Appeal.
And have 5 judges sitting, yeah.
Some quiet, rainy Thursday afternoon.
Yes, I suppose in this, at this point I can also mention that the effective intervention of this, the purchaser as a third party, the sale can still be set aside at this point. Now we're between contract and completion now, where the purchaser has notice of some impropriety with the sale, and the purchaser. It's not a question of whether the purchaser had such notice before the contract was signed. It could even be after. It's at any time before completion, and so the purchaser position can be affected if it does get notice at any time before completion that there was some irregularity with the sale, and invariably at that point it's going to be the mortgagor will be taking issue with the sale price and will be saying it's undervalued.
What about after completion? Are they left to damages?
Yes, after completion, I'm afraid that's well, certainly after registration of the T3 form of transfer from the mortgagee to the purchaser. That's thank you, linesmen and ball boys, for the mortgagor. its damages and essentially, but there are all sorts of difficulties with that. I mean, essentially, the mortgagor's got to show that the value of the land has to look at the true value of the land at the date of sale, and compare that to what it was sold for, taking into account, of course, all the money owing under the mortgage. There are, I mean, the MBF and Nolan case shows that there can be many difficulties with. It's an uphill battle, put it that way, but it's not to say it can't be done.
Can I just ask David a question? Up to what, when you talk about completion, up to what point could the thing be overturned?
I would say up until completion of the contract, although there is a rather difficult question of that interval between completion and registration, which can be a very, very short period of time. When the purchaser's protection arises on registration, and I suppose that might lead me to say that it could be any time up till registration.
So to go back to your point on the damages issue, quantification, I imagine, is going to be quite difficult because valuations are not set in stone. Even if you have one of those, actually ascertaining what would have happened, should have happened, is going to be difficult, isn't it?
Well, that's right, and there's also, Nolan shows there can be a difficulty in demonstrating that what the mortgagee did actually caused a loss to the mortgagor. The mortgagor has to show they've suffered a loss, but a loss that is, and we're talking about now, undervalued sale, but they have to suffer a loss which is caused by something that the mortgagee did, and that's not a lay down misere by any means.
So just changes in the market, for example, the fluctuations of the market won't necessarily be laid at the feet of a delaying mortgagee.
That's right, absolutely.
Looking at matters from the point of view of the incoming opportunistic carpetbagger, I beg your pardon, I mean the incoming purchaser, what sort of matters should they check if they're buying in a mortgagee power of sale?
Okay, well, in short scope, what a purchaser should do is to make sure that the mortgagee is, under the terms of the contract, selling the land as the registered proprietor of a registered mortgage over the title to the land. That's important. There should also be proper evidence in the contract or the vendor statement, or both, that of the mortgagee's entitlement to sell. So that usually one would find the mortgage will be, and MCP will be in the vendor statement. There'll also be the notice or demand that was given under Section 76. But apart from that, the purchaser does have some protection under Section 77, subsection 4 of the TLA. It says that the title of the purchaser is not impeachable on the ground that no case had arisen to authorise the sale, or that due notice was not given, etc., etc. And it goes on to say that a person thereby damnified shall have a remedy in damages. That's a reference to what the mortgagor can do, as I mentioned, even after completion of the sale. So there is that protection under Section 77, but it only arises upon registration. So the purchaser would be well advised to try and protect its position from the point of sale, from the point of the contract onwards. Mechanically, there has to be a T3 form of transfer. That's the way a mortgagee disposes of its interest in the land, and the statute then deals with the consequences of that. On registration of that, the land is vested in the purchaser as transferee, and it's freed from the mortgage pursuant to which the power of sale was exercised, and any subsequent mortgage recorded in the register. On the title itself, it's not going to say discharged. It will say no longer affects the land. That's an unusual notation on a certificate of title, but that's what it says. It reflects the reality that the mortgage is not in fact discharged. So the mortgagee is not going to hand over a discharged mortgage. Doesn't have to. That's the whole purpose of the T3 transfer. But it also follows from all of that because the mortgage isn't discharged, the mortgagee still has all the contractual rights against the mortgagor. For instance, if there's a shortfall, the mortgagor is still, and any guarantors are in the firing line to recoup any shortfall suffered by the mortgagee in the sale process. It's very different in the States where you just hand back the keys and that's it. The mortgagee gets back the property and you walk away and live happily ever after. But I'm afraid that's not the case in Victoria, at least.
I, in fact, own several dozen houses in Arizona, I understand, from that happy phenomenon. But that doesn't mean that the purchaser's there's going to be some recourse against the incoming purchaser after that transfer is passed over.
Look, the incoming purchaser is once registered, has all the protection that the statute gives it. There are a couple of, there are some exceptions. There's leases, for instance, to which the mortgagee is consented in writing or is a party to, but that the property would presumably be sold with the lease in place at that point. But otherwise, the title of the purchaser is unimpeachable.
And as you say, the recourse left to the mortgagee is the contractual covenant clauses of the mortgage.
Correct, yes.
Robert, does the purchaser have to agree to pay the price in one amount, or can the mortgagee sell for an amount payable by instalments?
The mortgagee can sell for a price payable by instalments and doesn't have to account to the mortgagor until the instalments come in. However, the situation's different if the mortgagee sells for a price but then accepts less and continues to allow that situation to happen. It's got to account to the mortgagor for the whole lot, even though the mortgagee hasn't received the money.
I beg your pardon. Does that happen from time to time?
I'm particularly here looking at some older cases where this has happened. I don't think a modern mortgagee would be so silly.
David, what technically happens to the mortgage interest on sale?
Yes, well, as I've said, the mortgage no longer affects the land, but it's not discharged, it still exists, and the mortgagor is can still be chased by the mortgagee for if there's a shortfall. If there isn't a shortfall, well, that's the end of the matter. There might be a surplus that has to be under Section 77, that has to be paid into court. If it can be paid either to the mortgagor or into court. And if there's any doubt, if there are other interests on title, the mortgagee, even if they disappear, such as subsequent mortgages and so on, or caveats, and I'll come to caveats in a minute, but the mortgagee, a prudent mortgagee, will always pay the money into court and not take the risk of paying it to the mortgagor if I'm talking about the surplus.
You were referring just then to caveats. What are the types? How does one go about removing them?
Yeah, that's one thing that another thing the purchaser has to watch out for. Now they're dealt with not in the sections of the Act that deal with mortgagee sales, but in the sections dealing with caveats. At Section 91 in particular, there's subsections 2A and 2B, and what they're designed to enable a mortgagee to have its sale without having to bother getting rid of caveats. Essentially, the sections are looking at money caveats, where a sum of money is secured and the caveat is lodged after the mortgage. Then those caveats don't prevent the T3 transfer being registered, and they lapse on registration of the T3. So therefore, they don't need to be removed. But of course, if there are other caveats, whatever they might be, a purchaser would be well advised to have them dealt with before handing over the purchase price balance. There is perhaps one exception to these money caveats if it's lodged by a local government, a council or a water authority, it might fall outside of the Section 91 provisions because of the Section 42(2)(f). These sorts of charges are exceptions to indefeasibility. So a purchaser has to be careful as to what caveats automatically fall away and what need to be dealt with, not at the purchaser's hands, but at the hands of the vendor or mortgagee.
Something for the solicitors to watch out for in that conveyancing transaction.
Very much so.
We've attempted to look at the mortgagee's power of sale from the point of view of the mortgagee, the mortgagor and incoming purchasers. Is there anything that anyone could possibly ask that we've left uncovered? Is there? We have a couple of minutes in case anyone does have pressing questions. Extra points will be awarded if the questions are submitted in either rhyme or haiku form. Yes, gentlemen.
Hi. Just going backwards right to the very beginning, if, off the top of your heads, if you could comment on mortgages where the mortgagor is the executor of a deceased estate, does the mortgagee have to make further inquiries other than looking at who's registered and so forth?
I don't know the answer to that.
I wouldn't have thought it's any different from the normal situation, just because there's an executor there standing in the shoes of the late mortgagor. I don't think there's any that adds anything to the equation.
No, I mean, it all comes back to did the mortgagee act appropriately, really? They would take into account the type of situation they're dealing with, but I don't think it would add any significant burden at all. I can't see why it would.
Come back next month for our fascinating wills and probate Q&A, where that will no doubt be discussed. Yes?
What about residential mortgages granted, residential tenancies granted without the consent of the mortgagee?
Well, in those situations, there's two issues with leases. Perhaps we could go back a step. David talked about indefeasibility of title. One exception, 42(2)(e) of the Transfer of Land Act, is if there is a tenant in possession prior, and the lease agreement was entered into prior to the mortgage being taken out, that tenancy is always protected. So, and you'll often see this happens, a mortgagee, someone purchases from a mortgagee and suddenly finds out that there was a sitting tenant. It's amazing that this can get this far, but it does. That tenant is protected under Section 42(2)(e) of the Transfer of Land Act. The other situation is when a tenancy is taken out after there is a mortgage and the mortgagee does not consent. The mortgagee does not consent in writing. The mortgagee is not bound by that tenancy, so that tenancy will go.
And that result comes about not by virtue of Section 42, the indefeasibility provision, but under Section 77(4).
Yes, that's right. And there's been cases, significant cases. I think Figgins Holdings dealt with one of these questions. Yes, so that's the situation.
Yes, the lady halfway down.
Thank you. How does the mortgagee's power of sale being executed change if there is a dispute, a family law dispute, a de facto or an ex-partner who's claiming either an interest in family law?
Neither of us are family lawyers, I'm afraid. So I have no idea how the family law courts treat those situations.
No, at the moment family law becomes involved, I run away as quickly as I can. I'll stick to what I know best.
Turn up the month after next for our family law CPD. Same place, same time. I think there's a question.
Sorry, an over-enthusiastic second mortgagee who is trying to control a sale, if they get in before the first mortgagee, what rights does the first mortgagee to say, I don't have confidence in the manner in which you're going to sell this property, I'm fearful that you won't achieve a sufficient sale price to pay us out, so we'd like to come in, or you're going to sign an authority with an agent agreeing to pay hundreds of thousands of dollars, which arguably will then take priority over the first mortgagee. what does if the first mortgagee is not the fastest cab off the rank, what can they do to stymie a more enthusiastic second mortgagee?
I'll just check that. I'm not sure whether that question was heard in the rest of the room. Very good, interesting issue. The position of subsequent mortgagees, whom, you'll forgive me for summarising it this way, who themselves have issues about the manner in which the sale is to be conducted by a first mortgagee and other way around, by the, yes, I meant that in the inverse way. What is that position and how do they decide that dispute between them?
Well, it's nothing to stop the second mortgagee selling, but a brave second mortgagee, in order to complete the sale contract, the second mortgagee would need to get a true discharge of mortgage from the first mortgagee, and the first mortgagee is not going to give it unless they're paid out in full. So the second mortgagee would either have to be very courageous or very prudent and check very carefully to make sure that the sale price, the expected sale price, is going to be enough to easily pay out the first mortgagee. I mean, otherwise, that sale may, the second mortgagee sale may end up going down the Zoomer, and the second mortgagee would be liable in damages to the purchaser for not completing, and we'll probably end up with the first mortgagee selling.
And are instances of that sort of overzealous second mortgagee, as mentioned in the question, are they common?
I've come across it, but it's not. Normally, the first mortgagee will be the one to start the ball rolling.
And indeed, I might, power of the microphone, I might ask the follow-up question, which is the obverse situation. Do subsequent mortgagees get to have any application based on the management of the first mortgagee's conduct of a sale?
The first mortgagee's got duties to consider the interests of the subsequent mortgagees, but they don't have to refer to them in the conduct of the sale.
Yes, follow-up question.
With the competing mortgage or sequential mortgagees like that, is there any ability to, other than buying out the first mortgagee, to compel the first mortgagee to tell you what they're owed? Because with the bank privacy rules, you could easily run into a brick wall, and the first mortgagee just says, "Well, I can't tell you what we're owed."
You could the subsequent mortgagees could make an application to court to require. Well, I mean, they've got to account to subsequent mortgagees, so they have to ultimately, if there is surplus money, it's got to be passed on one way or another.
But if you've got a second mortgagee trying to sell,
yeah,
how do they assess their position?
Well, that is very difficult. You're absolutely right. That is a real problem, and really the only way, in many ways, is to actually to take the thing into court, because that's the only way it could be protected.
It might be better just to let the first mortgagee sell.
Ladies and gentlemen, thank you so much for your enthusiastic attendance. We laughed, we cried, we went to work. There will be follow-up CPDs on other related matters, so stay on the mailing list, and we look forward to seeing you next time. Thank you for your attendance.